In this video, I want to talk a little bit more about arbitration and some of the more nuanced aspects of arbitration. Arbitration is governed by the agreement to arbitrate that's typically found in the agreement between the parties. Generally, the American Institute of Architects agreements and other form agreements have some sort of arbitration provision built into them. Those arbitration provisions that's basically the blueprint of what the arbitration is going to look like. So in your agreement, you can specify whether you're going to have one arbitrator, three arbitrators, whether discovery is going to be allowed in the arbitration, whether rules of evidence are going to be followed, and so forth. I think it's very important for parties that are negotiating these contracts to bring in somebody that really knows about arbitration procedures. What's good about arbitration, what's not so good. So for instance, do you really want to allow depositions and other types of discovery? These are discovery techniques used in court, and they tend to drive up the costs substantially. One of the big advantages of arbitration is that it's quicker and it's cheaper, or at least it's supposed to be. If you bring in all of these court procedures, you may find just the opposite, that it's lengthy and more expensive. All of this should be spelled out in the agreement to begin with. Another example is whether they have one or three arbitrators. The rules of the American Arbitration Association, if you're using them as your arbitration provider, spell out when you have three arbitrators versus one. Typically, it's over $1 million, you get three arbitrators, but you can certainly change that. The cost of arbitration is influenced by how many arbitrators you have. So the cost triples if you have three arbitrators. You might want to consider what the cutoff is for having three versus one. It might be smart to just have one arbitrator no matter what the size of the dispute. Nevertheless, this is all something you should discuss with your attorney when you're negotiating the original agreement among the parties. Another issue that's important, particularly in construction agreements, is whether you want to have joinders. So for instance, you're the owner. Do you want to have a single arbitration that includes the architect, the contractor, the subcontractors, the engineers, and so on? As an owner, you might think that's a good idea. It may not be. When you're actually involved in a dispute, do you want to have the contractor bringing in all kinds of subcontractors? That's going to make this more expensive and cumbersome. These are things you can put into your arbitration agreement. Don't just take the form as it's written by the form provider. Tailor your arbitration agreement to your needs and to how you see this thing being resolved. It's important to do that, and you're going to have a much better result at the end of the day.